Welcome to Environmental Law course, dear learner and viewer. Today we are going to discuss the international and national perspective of the biological diversity law. India embarked on the biodiversity legislation in 2003, although the policy in regard to the biodiversity conservation has been heralded in 1997. India is considered to be one of the mega biodiversity region of the world, and in this respect, any kind of the environmental law which we are going to pursue and study, the study of the international and national perspective of biological diversity law is something very important in the Indian context and as well as the international context. With this, we try to see that what is the significance of the biodiversity, and we find that the biodiversity refers to variety of the earth, including plants, animals, microorganisms, and ecosystem. And thus we find that India is one of the 12 mega biodiversity country with rich natural resources and traditional knowledge system. Therefore, the biodiversity in India supports food security. Number one, it supports livelihood. It supports ecosystem services. It also regulates the climate regulation, and it also covers obliquely the health issue of this country. However, we see that the biodiversity is threatened in the last 3-4 decades because of certain climatic conditions and overexploitation, pollution, land use change, and climate impact, which have necessitated to have a legal framework. So, India's concern of the biodiversity is well reflected by its rich biodiversity and as well as the formidable threat and challenges which have been posed in recent past in regard to the menacing level of the degradation of the forest and wildlife of the country. In this context, besides having realized the significance of the biodiversity, which is a fundamentally hierarchical system in the entire ecosystem, we will switch over to the Convention on Biological Diversity, which was adopted in 1992 at Rio Summit, which aims at conservation of the biodiversity, sustainable use of its component, and fair and equitable sharing of the benefit arising out of the genetic resources. The Biodiversity Convention for the first time have introduced the notion of the equitable benefit sharing. Therefore, it has given rise to another two concepts, that is prior informed consent and mutually agreed terms, so that the very regime of the equitable benefit sharing can trigger very well in the legal domain. Therefore, while accessing the biological resources, the India ratified, while accessing the biological resources, what is required, that there must be a kind of a prior informed consent and the mutually agreed term by the user and the provider country in relation to sustainable use of the biological diversity at national and international level. India has been quick enough to fulfill its commitment by the Convention on Biological Diversity 1992 by ratifying this in 1994. Thus, from 1994, 1992, 1994, India was in search of a legislative framework which can encompass all the richness and all the variety and all the diversity of one of the 12 mega biodiversity region of the world. This resulted into certain enactment and certain policy, and the national biological diversity legislation and the policy we have received. But prior to that, we see that the refinement in the CBD, because once the CBD was put into operation in 1992, that CBD has underlined the need of fair and equitable benefit sharing, and this is something very important and cardinal to the CBD convention, and therefore the fair and equitable sharing of the benefit have resulted into giving rise to not only the prior informed consent, not only the mutually agreed term, but it also try to give emphasis on the benefit sharing, environment impact assessment, technology transfer, EIA, principles of EIA, technology transfer, and then we try to see that the national guidance and national sustenance to this law can only be achieved if at international level this Convention on Biological Diversity 1992 come out with a very detailed and clarified provisions of the prior informed consent, mutually agreed term, environment impact assessment, technology transfer, and user user and provider country to have the access of the biological resources. Therefore, the mandate of the National Biodiversity Law, which has its genesis under the Convention on Biological Diversity, the India formulated National Biodiversity Action Plan in 2008 and 2014. But prior to that, India also had a conservation of biological diversity policy in 1997, because when Rio Plus 5 summit was there, that the Indian Minister for Environment participated in the Rio Plus 5 summit, and then India have quickly prepared a draft of the biological diversity policy in 1997 itself. Therefore, we see that whatever has been done under the biological diversity policy in 1997, it has reached to its culminating point by drafting the National Biodiversity Action Plan in 2008 and 2014. The problem actually happens to be that when we are going to translate the objective of the fair and equitable benefit sharing, it has given rise to number one, the Bond guidelines, because it is easier to say for that how the benefit sharing and how the fair and equitable benefit sharing are going to be operated under the framework of the Convention on Biological Diversity. Therefore, in 2001, there was a guideline which have detailed out the intricacies and delicacies and the practicalities of the fair and equitable benefit sharing. This fair and equitable benefit sharing also resulted into Cartagena Protocol on biosafety, and it also resulted into Nagoya Protocol in 2010, 2004. So we see that one of the most difficult provision was to have its legal translation and to develop a kind of a legal regime to see that the biodiversity is not only to be sustainably used but conserved, and the country exercises sovereignty over the biodiversity resources, and there should be a law which can guide for the access of the biological resources with the prior informed consent, mutually agreed term, and environment impact assessment, technology transfer. Thus, it requires a certain delineation, and that delineation has been done in Bond Guideline, Cartagena Protocol, and the Nagoya Protocol. This completes the very essence of the Convention on Biological Diversity. It was heavily dependent on three subsequent protocols and guidelines, and thus it refines the entire basic precept which has been permeated into Convention on Biological Diversity 1992. With this mandate, there is another mandate which has been conferred, and that mandate happens to be the Aichi target, which was launched in 2011 and 2020, and therefore the Aichi target which was set for the biodiversity conservation after putting, and the year of the Aichi target is important because either it is CBD, either it is Cartagena, it is either it is Bonn, either it is Nagoya. All kind of legal exercise have reached to its culminating and penultimate point. That's why then the CBD Secretariat have launched the Aichi target in 2011 to 2020, and thereby what we see that the mandate of the National Biodiversity Law have to look at one hand the Convention on Biological Diversity, on the other hand the Bond Guideline, on the other hand the Cartagena Protocol on Biosafety, on the other hand the Nagoya Protocol of access of benefit sharing, of 2009 or 2010, and thus it gives the genesis and the mandate of the National Biodiversity Law to be framed. With this, we see that the National Biodiversity Legislation India enacted in 2002 and it was implemented in right earnest. Thus, we see that the law which covers conservation measures, law which covers the access regulation, the law which covers the traditional knowledge, the law which cover the benefit sharing mechanism, all has been tried to be translated under the National Biodiversity Legislation of 2002 vis-a-vis its emphasis on the vis-a-vis it is to be actualized by creation of the National Biodiversity Authority, State Biodiversity Board, and the block biodiversity management committee at the level of the block and the villages. So we see a three-tier system of the conservation of the biological diversity has been put forth by the Biological Diversity Act of 2002 under the backdrop of the legal endeavors which were right from 1992 to 2010. It took almost 18 years to see that the entire international law relating to biodiversity conservation reached to its zenith, and after promulgating the ACHI target of 2011 to 2020, it has heralded a new notion and a kind of a mature legal system, and India also tried to seek some of the finest point of the international law as well as the Aichi target under Biodiversity Act, Biodiversity Rule, and the access and benefit sharing regulation which it has tried to uh, which the Ministry of Environment and Forest and Climate Change have brought in 2014. So at one hand, what we see this Convention on Biological Diversity 1992. On the other hand, we see the Bonn Guidelines of 2001. On the other hand, we see that Nagoya Protocol on Biosafety. On the other hand, we see Cartagena Protocol on Biosafety, and then we see Nagoya Protocol in relation to access and benefit sharing. On Indian aspect, we have a National Biodiversity Conservation of Biological Diversity Act 2002, and then we have a Biodiversity Conservation Rule, and then we have Access and Benefit Sharing Guideline of 2014. That taken together, the international law and the national law, which is the theme of the present lecture, that international and national perspective and the biological diversity law, having prefaced the international and national perspective of the biological diversity law, we can say that India have also renovated its biodiversity conservation legislation, and it has given rise to each and every segment and the fundamental principles of the biodiversity conservation into its right earnest. Therefore, what we will see that what are the salient features of the biodiversity law, and we will also see that how the protection of the biodiversity and associated knowledge and sustainable use provision, because the word sustainable use of the biological resources, biodiversity resources, is very important and very central to this law. And then it wanted to try to regulate the access of the resources in terms of sustainability. It also tried to see a different system of the IPR, which is community oriented, which is not a corporate oriented, and this is a fundamental difference between the CBD and TRIPS agreement, where the TRIPS agreement takes a very corporate perspective of the intellectual property. That is not the case, and through the access and benefit share mechanism, it included monetary and non-monetary benefit to see that biodiversity conservation should be nurtured by the community who happens to involve by traditional wisdom since time immemorial, and a system of incentive and reward was created, and it incorporated from right from the very beginning the role of the local communities, and it is established at the three-tier center, state, and the local level. Thus, we see the biological diversity which has been defined under Section 2 of the Act, which defines biological diversity as variability of living organism, and biological resources include the plants, animals, microorganisms and their genetic material. And in the context of the biological diversity, which actually connote to variability among the living organism and encompassing plant, animal, microorganism and their genetic material, it should be used and accessed in a very sustainable manner in a short term and the long term, and all the value added product process material are to be regulated under this. Then we will try to see that how this law have been constitutionally tested and challenged by a series of the cases before the different courts in India, and we will try to see, despite its constitutional challenge and validity and the veracity, the biological diversity law of 2002, including its rule and the access and benefit sharing guidelines, have survived the test of the time because of the emphatic role of the central government and the court to see this law should achieve its objective and target. The knowledge which are said to be associated with the biological resources, the Act covers that. It talks about number one, the biosurvey, it talks about the bioutilization, it talks about the commercial utilization, it talks about the research involving biological process, and at the same time having what is the knowledge associated with the biological resources, it also try to devote to the question of traditional knowledge at one hand and probe the communitarian approach and their right in ensuring the benefit sharing regime. So, the logical question now is that who are the person who are entitled to access the biological resources? Then Act recognizes the foreign individual or entities, non-resident Indian, Indian entities, Indian citizen, foreign NRI need National Biodiversity Authority's approval for access of the research, IPR and biosurvey. So, this approval of the National Biodiversity Authority for any foreign individual and NRI is mandatory under this law. Then the intellectual property dimension, as has been explained earlier, that the intellectual property dimensions of this law is very important and has permeated under section 3 to 7 and section 19 to 21, which regulate the intellectual property rights dimensions of the biological resources. And the key requirement under these provision appears to be that it is mandatory that in all the cases for access of the biological resources by the user in the provider country, besides having a PIC mechanism, prior informed consent and mutually agreed term, it must have a mandatory approval of the National Biological Diversity Authority before patenting and sealing. And on the other hand, we see that the fair and equitable benefit sharing is being regulated by a procedural safeguard which has been given into filing of the Form 3, which tries to give an IPR related application, and in certain cases the law also grants some kind of the exemption in relation to the plant variety protection under the Plant Variety Protection and Farmers' Rights Act in India. Thus, we see that this law is also very important from the standpoint when we talk of the biodiversity law, biodiversity act, we talk of biodiversity rule, and then we also talk that plant variety protection and farmer rights act. These three law plus one guideline in relation to the biodiversity access 2014 is very important to give a clear picture and a holistic picture and a rounded view of the biological diversity legislation. So, in this reference, we see there is an exemption in relation to the plant variety. Thus, the patenting of the biological resources conflict between the Patent Act and the CBD. So, what are the anomalies which are crept into the India's patent law or the patent perception of the biological resources? So, that has to be reconciled, and therefore, in this context, we can cite the draft patent rule of 2015, which tries to sort out the anomalies which exist. As I have already explained earlier, that it is a community, it is a biological diversity driven intellectual property. It's not a trade related aspect of intellectual property, right? Therefore, so the anomalies and incongruencies between the Patent Act in accessing of the biological resources as well as the biodiversity resources need to be harmonized and need to be those loopholes must be plugged into, and therefore in that reference the draft patent rule 2014 along with the compliance of section 6 of the biodiversity act becomes very important. So what we see that under the strength of this law, we have a large number of cases of the violation of the benefit access of the biological resources violations by Indian and as well as the foreign, and therefore the first case on the point happens to be the Research Foundation versus the Union of India, which talks about the wheat patent case, where the Supreme Court have unfortunately declined for any kind of intervention but supported biodiversity protection. On another case known as Jagannath versus Jagannath case, we see that highlighted the need to clarify between the Patent Act and the biodiversity, because that confusion is getting more compounded when we try to see that the moral foundation of the patent law or the trade related aspect of intellectual property is something different, and the biodiversity related intellectual property rights laws are something different. Therefore, the incongruencies and incompatibility must be sorted out. So, again with this kind of the synopsis, we will try to see at a glance that what is the Convention on Biological Diversity which has been entered into. So, what was the international law? The international law was Biodiversity Convention and the Rio Summit, and India signs in 1923. It comes into force and India ratifies it. India becomes a party, Parliament has implemented this law, the act has been notified, and central BD rules was also notified by Ministry of Environment and Forest and Climate Change, and NGT has also inserted and given importance to the biodiversity dispute under section 52A. So, we see that the Convention on Biological Diversity being the grand norm of the biodiversity law have been replicated into the national jurisdiction with a great hurry and haste, and we see that there was a deeper commitment of the biodiversity law, biodiversity rule, access and benefit sharing guideline, and as well as its suitable adjustment under the National Green Tribunal Act under section 52A. Thus, we see that the basic ethos of the CBD, along with Cartagena Protocol on Biosafety, Bonn Guidelines, Nagoya Protocol on Access and Benefit Sharing, have reached to ultimate objective of sustainable use, sovereignty over natural resources. Because sovereignty over natural resources is very important in this law, because the intellectual property of the biological resources is termed as the sovereign resources of the country. It is not, again I am saying about the TRIPS agreement, which says that talks of the free market and the globalization. Then in that sense of globalization, that CBD reject this law is to make subservient to the corporate giant, but it vests the entire confidence of the state, and thus by having sovereignty over natural resources as one of the fundamental principles, it try to see sustainable use of biological resources, fair and equitable sharing of the benefit, and commercial use and transfer of the biological diversity resources under a strict law, which is to be done in conformity of the biological diversity law at national level. Therefore, the objective of the biodiversity law, which has been underpinned mainly, is the Article 15, subclause 1, subclause 2, subclause 6, which talks about the grant the state the right to legislate the genetic resources and ensure some access and impose restriction in matters of participation of scientific research and fostering information and sharing. So this permit system is not influenced by the World Trade Organization, and it adopts a PIC and MAT mechanism, that is mutually agreed term and a consensual approach and prior informed consent between the user and the provider country. Thus, whatever has been the mandate of Article 15, then Article 16, which talks about the strategies and schemes to be adopted. Article 7 talks about protection of the threatened species. Article 8 is very important, and that is also, if two articles are very important, then Article 15, Article 8. And Article 8 is talking about the ex situ and in situ conservation of the habitat, whereas the environment impact assessment questions are addressed in the Article 14. Article 15 talks about again the equitable benefit sharing from the research and development, and Article 16 promotes access and transfer of technology. That is also very important, and that is one of the basic fundamental of the basics of this convention, which try to foster a kind of a regime of transfer of the property for the access of the biological resources on mutually agreed term and the prior informed consent. With this, see, from this point of view, what we see that United Nations Environment Program's Montevideo Program 2001, which has emphasizes that there must be an national enforcement of environmental law, including biodiversity, and it is under the genesis of this law that the National Biodiversity Law was enacted in 2002, and therefore what has been said under Article 14 of the Montevideo Program, third, and the CBD obligation, along with Article 6 of the Convention on Biological Diversity, India adopted that uh, that enactment, and India passed that act, and it has also launched that National Biodiversity Strategy and Action Plan project from 2000-2004, and thus we see that including the national legislation and biodiversity law coupled with National Biodiversity Strategy and Action Plan, we see that the entire objective of the CBD has to be fulfilled, along with what the HE target, the 20 HE target, which has been mentioned, and it is in consonance with the 20 HE targets, which serves a global framework for actualization the objective of the biodiversity law. And thus we see that in Indian context, the law which we have as of now, that the Biodiversity Conservation Act, Biodiversity Rule, Access and Benefit Sharing Guidelines, and National Biodiversity Strategy and Action Plan are in consonance with all three fundamentals of the international law on biodiversity. Thus, in this context, we see that the national biodiversity legislation has seen a kind of a great change in the entire corpus of the environmental law, and the features of the Biodiversity Act 2002, which have recognized IPR in a different connotation and context, is also important, not only recognizing the sovereignty over the natural resources, not only recognizing the sustainable use, not only recognizing the equitable benefit sharing, not only recognizing the transfer of technology between the user and provider country, having access of the biological diversity, and not only recognizing the EIA principle, but the very essence and object of India's concern of the biodiversity is being addressed at the constitution of the Biodiversity Management Committee at the block level, and the State Biodiversity Board at a state level, and National Biodiversity Authority at national level, having its office in Chennai. And then we try to see the how this law have also come out from its the constitutional challenge in R. Muralidharan case, Chandrabhal Singh versus Union of India, Planters Forum versus State of Kerala, and the cases in point all happens to challenge the veracity of the Article 253 and the approach which the India has adopted. Nonetheless, the judicial decisions support unequivocally about the framework and the need of this law, and thus we see that the national international biodiversity law and the national biodiversity law in India has achieved to a greater extent, and it has given rise to a kind of a jurisprudence which is a very novel addition into India's corpus of the environmental law. With this, I thank and I wish you a happy learning.